Good day, everyone. This is a criminal law presentation for Group 2 on the topic murder.
Definition of murder. Murder, by the Black's Law Dictionary, can be defined as the unlawful killing of a person or a human being with malice aforethought. Generally, murder can be defined as the unlawful killing of a person under such circumstances that can make him criminally liable for death with the required intent or malice.
According to Section 216, except as herein after such counts, a person who unlawfully kills another person under any of such the following circumstances, that is to say, 1. If the offender intends to cause the death of the person killed or that of some other person. 2. If the offender intends to do to the person killed or some other person grievous harm. Number 3. If the death is caused by means of an act of the prosecution of an unlawful purpose, and such act is such of a nature as likely to endanger human life. Number 4. If the offender intends to do grievous harm to some person for the purpose of facilitating the commission of an offence of which the offender may be arrested without warrant, or for the purpose of facilitating the flight of an offender that has committed or attempted to commit any of such offence. 5. If the death is caused by administering, superfine or overpowering things. And number 6. If the death is caused by willfully stopping the breath of any person, either of such purposes. In the second case, it is immaterial if the offender does not intend to cause the particular person killed. In the third case, it is immaterial if the offender does not intend to hurt any person. And in the 3 last cases, it is immaterial if the offender does not intend to cause death or does not intend that death might likely to result.
The elements of murder, that the disease died, that it was the act of the accused that caused the death of the deceased, that the accused acted intentionally, knowing that death occurred period and the probable consequences of his action. Now, explaining the first element, that the disease died, is it necessary for the prosecution to produce the evidence for the corpus delicti in sustaining the first ingredient, that is the dead body? Let's see the case of Mrs. Roberts of the state, where the appellant and 3 others were charged with culpable homicide, punishable by death in the criminal code. The fact of the case goes first. A motorcycle was alleged to have been stolen, in which the appellant was a suspect. So, Constable Rotimi Jeremiah took the appellant in order to produce the particulars of the motorcycle. But that was the last time it was last seen alive. So during the investigation, the appellant said we produced both oral confession and written statement that they had gone, he and the other co-accused had gone and killed the appellant. So they were arrested and they were led to the crime scene. When they got to the crime scene, they were led by the police to the crime scene. When they got to the crime scene, the last known cause of the disease, a teeth and some strand of hair were found in the crime scene. So during trial, he retracted his confessional statement saying that he never killed the disease, but the judge did not accept this and he was convicted and sentenced to death. He appealed to the Court of Appeal, where his case was dismissed. He further appealed to the Court of Appeal, alleging that the case was not proved beyond reasonable doubt, and the fact that the inability of the prosecution to produce the corpus delicti and some other unanswered questions like what type of fire that was even burning the disease. But based on the last same principle, they had the obligation to explain the whereabouts of the disease. So at the Supreme Court, they affirmed the judgment of the lower court and was sentenced to death.
The second element of murder, which is that the act of violence led to the death of the also as causation. Causation simply means that there must be a clear link between the act of the accused and the death of the disease, which means that prosecution must prove beyond reasonable doubt that an act or omission of the accused led to the death. For example, if a person stabs another and the victim dies as a result of the injury inflicted, causation is established.
The act of the accused must be intentional with the knowledge that his act will cause death or grievous bodily harm. The intention to cause death or grievous bodily harm must be evident. Odunlami versus Nigerian Navy and Ago-Iwoye Bikole versus State are Nigerian cases that support this element.
Section 310 of the Criminal Code provides that a person who by threat or intimidation or by deceit causes another person to do an act or make an omission which results in the death of that other person is deemed to have killed him.
Section 311 of the Criminal Code talks about acceleration of death. It states that any person who does an act or makes an omission that hastens the death of another person who at the time that the act or omission was done was laboring under some disorder or disease is deemed to have killed that person. And this means that the accused person cannot claim liability by stating that the person was already dying, as long as the act or the omission of the person hastened the death of the deceased. The law states that he has killed that person.
By virtue of the provision of Section 312 of the Criminal Code Act, in a circumstance or situation where a person causes bodily injury to a person from which death results, the Criminal Code Act proceeds and provides that it is immaterial that such injury can be avoided by proper precaution on the part of the person that has been injured, or that the death can be prevented by proper cure.
Injury causing death in consequence of such injury. By the virtue of Section 313 of the Criminal Code, when a person causes harm to another and the other has to resort to surgical or medical treatment, and death results either from the treatment or the injury, he is deemed to have killed the other person. Although the immediate cause of death was from the surgical or medical treatment, provided that the treatment was reasonably proper under the circumstances and was applied in good faith.
Limitations as to time of death. Section 314 of the Criminal Code states that a person is not deemed to have killed another if the death of the other person does not take place within a year and a day of the cause of death. Such a period is reckoned inclusive of the day on which the last unlawful act contributing to the cause of death was done.
In conclusion, murder is an unlawful homicide under Section 316. In secure conviction, the prosecution must prove three key elements beyond the evidence, which is death, intent, and consequence. We can prove the offense of murder through via conversion, direct evidence, and circumstantial evidence, such as the lancing principle, which shift to the accused to explain the victim's fate. If there is intent to cause death and harm, then the accused is guilty of murder.